Hello everyone, and welcome back to another insightful episode of Qanoon or Adalat. I'm your host, Yola, and today we're diving into a powerful and complex judgment delivered by the Lahore High Court, Rawalpindi Bench. This case uncovers vital legal doctrines around family settlements, partition of joint property, and the consequences of purchasing property during litigation, all wrapped up in one riveting story. Joining us today is Mr. Moin Ahmed, Advocate High Court. Now this time, he wasn't the arguing counsel, but he's here as our legal storyteller and commentator to walk us through what actually happened in this case and what it means for the law and for ordinary citizens. Mr. Moin, welcome.
Thank you. It's always a pleasure to be here, and this case really offers a great opportunity to unpack some deep-rooted issues in property law in a way that's accessible for everyone.
Let's start with the story behind this case. Imagine a large family, multiple marriages, multiple heirs, and then years later, a fight over inheritance. What happened here?
That's exactly what happened. The property belonged to a man named Muhammad Aslam. He had 3 marriages, and after his death, many of his children and widows inherited the property. Eventually, a few legal heirs filed a suit saying they wanted a formal partition because the property was still jointly owned, but others resisted, claiming that the property had already been divided among the family informally. The complicated things further get complicated when one buyer, Mubarak Ahmed, purchased a portion of a property while the case was still ongoing and claimed exclusive ownership.
A family claiming they had already divided the property privately. Is that a common situation?
Very common. Especially in rural and semi-urban areas, families often divide properties through oral understandings, what they call family settlements, without ever registering anything formally. But that's where problems start. The law does allow private partitions, but only if they are later affirmed by the revenue authorities. Without that affirmation, such divisions don't carry legal weight.
So let me ask on behalf of our audience. If your family has divided property informally, is that legally safe?
Great question. The short answer is no, not completely. Unless the family applies to a revenue officer and get the private settlement affirmed officially, the property remains legally joint. Any co-owner can later file for partition, and courts will treat it as unpartitioned. This case is a textbook example for that.
Okay, now here's a twist. One man, Mubarak Ahmad, purchases a part of the property during the dispute. What's the legal standing of a buyer like that?
That's where the doctrine of lis pendens comes in, a Latin phrase meaning while litigation is pending. When someone buys property that's part of an active court case, they inherit the same legal risks as the seller. The High Court said clearly Mubarak Ahmed may have purchased in good faith, but he bought during litigation, so he can't claim anything more than what his seller legally owned.
So no matter how clean or registered the sale deed is, the timing can still ruin the deal?
Exactly. The court validated the deed only to the extent that it matched the seller's legal share. But the buyer cannot say, "This corner room is mine," just because it was in the sale deed. He'll have to wait for the final partition, and whatever land falls in his share, only then will he have full rights.
Pause here. If someone listening is about to buy property that's inherited, what's the one thing they should double check first?
Ask this: is the property partitioned or still joint? Get a certified copy of the latest revenue record. If it says joint, you must understand you are buying a share, not a specific portion. And always check if there is any ongoing litigation. Otherwise, you are stepping into legal quicksand.
Back to the case. What happened to Mubarak Ahmad's claim that he bought a specific portion?
The court said he could retain his rights as co-owner, but only in proportion to the seller's share. So he's not kicked out, but he doesn't get exclusive possession either. He'll have to participate in the final partition process, just like every other co-owner.
There was also a claim that not all properties were included in the suit. Was that a strong point?
The court found it to be vague and unsupported. If you are alleging that the suit is barred due to partial partition, you need to clearly list which properties were left out. Here, no one gave specifics, so the court dismissed that argument as hollow.
Let's talk about how the court viewed family settlements in general. What's the big lesson here?
The court made it absolutely clear Private settlements are not enough unless affirmed by a revenue officer under Section 147 of the Land Revenue Act. Just saying we divided it among ourselves isn't good enough. It must be registered or at least affirmed officially. Otherwise, joint ownership remains.
How did the court view the credibility of the parties who objected to the suit?
The court was very clear. If a party raises objections, they must support them with proper documentation and evidence. Vague allegations, oral assertions, or inconsistencies in the written statement won't help. That's why the objections about prior partition or omitted properties didn't survive judicial scrutiny.
What if someone genuinely doesn't know that a family settlement needs to be formalized? Is ignorance a defense?
Unfortunately, no. In property law, especially concerning partition, the law assumes that people will take steps to secure their rights properly. Ignorance may be understandable, but it won't save a claim that lacks legal standing. That's why legal awareness is crucial.
Let's look at the broader picture. What message does this judgment send to buyers and investors?
The judgment sends a strong message: do your due diligence. Just because a sale deed is registered doesn't mean the property is dispute-free. You must check the title status, joint ownership records, and any pending suits. Always consult a competent property lawyer before investing.
Do you think courts are becoming more strict in partition and co-ownership matters?
Yes, and rightly so. With increasing litigation around inheritance and joint property, courts are emphasizing procedural compliance and clear evidence. The judiciary is now less tolerant of vague, unsubstantiated claims or casual treatment of joint property.
Was there any part of this judgment that particularly stood out to you as a lawyer?
Yes, the court's consistent reliance on established precedent and statutes like Section 52 of the Transfer of Property Act and Section 147 of the Land Revenue Act stood out. It shows that even complex family disputes can be resolved clearly if the courts remain anchored in well-settled law.
Final words, Mr. Moin. What should every co-owner or legal heir remember after listening to this episode?
So simple. Don't rely on oral promises. Get your family settlement documented and legally affirmed. And if you are a buyer, especially in inherited or joint property, don't skip due diligence. Respecting the law from day one can save you years of litigation.
That was incredibly insightful. Thank you so much, Moin Ahmed, for breaking down such a dense and important judgment for us. To our listeners, always remember, what you don't know about your property can hurt you. Stay informed, stay protected, and keep following Qanoon or Adalat for real legal stories that matter.
Thank you. It's always a pleasure to explain the law in a way people can use and understand. Until next time, Khuda Hafiz. And please subscribe the channel and comment your question if you have any.